Governors. I chair the Wsba Diversity Committee, and I'm on the Executive Committee. Talking about the work, the structures work group, it is our view that this legislation is actually premature. And there may be unintended consequences that we really want to avoid. It is unclear what the problem is that is trying to be solved, but there's work going on right now where at the conclusion of its work, we will all be informed in terms of what would be the better structure or the best structure for the Washington State Bar Association. And then we'd be informed on what legislative changes would be required and desired. Those legislative changes could range everything from the bill as it's being advanced to actually just determining surgically to make certain amendments to the Bar Act. We would prefer to come back to you once the work of the Structures Work Group has been done and actually then be informed on what's the best approach to take.
Thank you. Please proceed.
Good morning, Chair Peterson and distinguished members of the committee. My name is Paul Swigel. I serve on the Board of Governors and represent District 7 North, so that is about 5,000 members from Ballard, where I live, up to Edmonds North. And as Governor Schicchetti said, I will be serving on the structure work group and look forward to looking at those constitutional issues to figure out what is exactly in the very best interest of the public, and the members, the employees of the Bar Association, and versus going forward with 1788, which I think is a little bit like, getting on a journey without a map or any directions. I don't understand the role that this legislation would play, and I find it very disruptive. By way of background, I'm a business attorney and a deal attorney. I've done lots of restructurings, I've done lots of business purchases, sales, and mergers. And whenever I give advice about a deal and how to structure it and whether or not to go forward, I take an inventory of a lot of things. What are the assets? What are the liabilities? What sort of intellectual property rights are involved? What sort of contracts are involved, and are they assignable? I look at the interests of the employees. I look at whether or not there's any pending disputes that would be problematic to try and move over. And I also look at the presence of stakeholders and whether or not they need to be courted in order to not have litigation after a deal. So, essentially none of that has been done at this point. None of that sort of deal planning of like, what is the best structure? We're just dissolving the bar and creating a new entity under the court without an understanding of how that impacts this huge organization. This organization is every bit as complicated, and its restructuring every bit as complicated as any business deal. It's a $20 million a year deal. It has literally millions of stakeholders, more than 150 employees. We've got 40,000 members whose rights and interests need to be considered. They need to be consulted. We have a $4.8 million lease. We don't know how any of this is going to play out if we just dissolve the entity and move everything to the court. I think that there's a lot of unintended consequences that occur. There's 29 sections that have $1.2 million of financial reserves. If those go to the court and get stuck there, how would they get back to the members who voluntarily contributed those to the sections? Those are assets of the sections. The members voluntarily contributed them. The sections earned those by putting on CLEs. Anything that goes to the court in a government agency cannot be gifted back under the Washington State Constitution, which prohibits the gift of private funds. So I think that there's a lot of issues around that, and I believe that Rajiv Majumdar will pick up on some of those unintended consequences. But I think a huge problem is if we enact this bill, fixing it later could be a huge problem. We don't know what sort of legislation folks will be amenable to fixing these issues. So it's a lot easier right now to prevent the problems before they start and to post 1788. Thank you.
Thank you. Please proceed.
Thank you, Mr. Chairman. Rajiv Majumdar from Whatcom County. I'm the president-elect of the Washington State Bar Association. I previously served as the governor representing the Federal Congressional 2nd District. That's most of Northwest Coastal Washington. Thank you for hearing our opposition to this, because this is a serious issue that we take very seriously. We take our fiduciary duty seriously, and we're all volunteers. We've got many hours trying to do the right things and bring about good governance for the people of the state. I became a lawyer because I believe in public service. I wanted to serve my community. And the Washington State Bar Association, let's set aside the concerns of the lawyer, the structural concerns. It does massive amounts of efforts on behalf of the public good and community that may not be able to be preserved if it's transferred to the court, such as gifting the Client Protection Fund of $3 million that gifts to people who have been harmed by dishonest lawyers. We fund the Washington Leadership Initiative, which funds younger attorneys from underrepresented backgrounds to become better attorneys and better leaders in the legal community. And our court's view of plenary power may be out of sync with the federal view of plenary power. And if these cases come to some resolution that dictates the current form is unacceptable, which I don't believe it will, but the federal view of plenary authority could be a lot more narrow than our court's view of plenary authority. And that would require a sudden excising of things that have been hurriedly transferred to the state. This is a lot more like Brexit and a solution looking for a problem than a well-crafted, well-intended thing. There's a lot of work being done by experts. Let's let those experts do the work. And when the framers in this body drafted the Bar Act, I think they were wise. They crafted it in a democratic manner with representation from across the geography. And I truly appreciate the democratic impulses that are behind the Bar Association. And I think it's produced good governance. It's served the state very well since its charter in 1933 and all the way back to its founding 1 year before the foundation of the state. Thank you so much for your time.
Thank you. Before we let you all go, I guess the question that I have, it seems like you were testifying mostly on the original bill and not on the striking amendment. And 2 points in particular, I guess I just want to hear a response to. So existing 248.010 says there is hereby created as an agency of the state for the purpose and with the powers hereinafter set forth in association to be known as the Washington State Bar Association. I guess I am not clear if there's a problem with gift of public funds. It's not apparent to me why it becomes any more of a problem after this than it is right now. We've been living, obviously, with the Client Protection Fund, for example, already. But if being an agency of the state means that you can't give away public funds, I don't understand why that becomes more of a problem after, if this bill were enacted. Does anybody have a response to that?
Just briefly, I'll note that the Bar Act isn't a perfect bill. It also, other language in the bill sets it up essentially as a chartered corporation of the state, as corporations or big enterprises used to be chartered by the state before a Corporations Act or a Non-Profit Corporation Act. I'm not sure I have an answer at hand, but I will say that there is ambiguity in the bill. It seems to be a hybrid. That original bill also recognizes the plenary power of the court, and it seems like it's kind of a hybrid public/chartered corporate entity, and we've been able to harvest advantages of both sides of that this far in our existence. And I'd hate to just cut anything off short. We need to have the most maneuverability. So if the court decides something needs to be done, or if case law decides something needs to be done, we have that flexibility to move one direction or the other.
Well, I guess that's the other question. So it's quite clear that because if we enact the bill, we're recodifying that section. It's quite clear that the existing agency is not dissolved. The existing agency continues exactly as it is. I think the questions about leases and contracts and ongoing litigation are a bit of a red herring. So what I guess I don't understand is we've got a lot of other provisions that the legislature added in 1933 that I think for decades There's been some question whether we had the constitutional power to put in place. If what we're trying to do is maintain flexibility for the court and the structures work group, why isn't it the right answer to clear some of that out of the way so that the structures work group and the court then have the most room to create the solution that they end up thinking is appropriate under the circumstances?
So if I could address that.
Please.
As part of that structures work group, we have met with the court preliminarily. We haven't started any of our work yet. It's going to begin on March 28th. And no one has any predetermined idea, including the Chief Justice, on what our conclusions will be. And so by preserving the WSBA Board of Governors and many of the statutes included in that statute, it just gives us flexibility. Say we decide that at some point we're going to go with a split bar, bifurcated bar, and we'll have mandatory discipline under one section and then a voluntary bar. Washington State Bar Association, the Board of Governors, the statutes within that, the State Bar Act, would continue and would govern perhaps that voluntary bar. Maybe that's not the way that we're going to go. Maybe there's also some case law that I didn't cite, but that talk about, and I would recommend that the committee look into some of these cases because they are the central focus of what the work group is designed to look at. 1961 U.S. Supreme Court case that talks about one importance of having not a free speech issue with regard to the dues is a democratically elected Board of Governors. And there's no doubt in the Strike Amendment that this does away with that component of the State Bar Act. I conclude with the fact I'm from Vancouver, Washington. I also practiced in Oregon. Oregon also has an integrated bar association, much like Washington's. They are grappling with the same issues. They have, and I just had a conversation with a member of the Board of Governors last week, they are not considering doing away with the Oregon State Bar Act. They're amending it to bring it within the judicial department of the courts as one option to figure out how to deal with Janus and these other cases. But no one has suggested in Oregon that they do away entirely with the Oregon State Bar Act to address those concerns. These will all be discussion topics during the structures work group, but we want to preserve our options for purposes of the fact that we've only been discussing this for about a month now, and we want to make this a careful and considered approach to figuring out what the future of the Bar Association is going to look like.
Senator Cousin.
Yeah, I just don't hear from any of you a realization is how the Bar Association is perceived. We had hearings a couple of years ago and on some of these issues. You talk about fiduciary duties. You talk about members' rights. And yet you pick and choose what part of your bylaws you're going to honor. And when a number of the Bar Association members gathered enough signatures for you to put a vote out to the membership, you failed in your fiduciary duties to do that. And so it's not surprising to me that the House voted 96-1 to present this bill. I think the chair has some thoughtful things, including a delayed implementation date. There's still, some concerns we have, but I considered after your decision not to put that vote to the membership as required by your bylaws. To me, you became illegitimate as of that time, and I still see you that way. And a lot of attorneys see you that way. Certainly, I'm sure you're aware that a lot of the impetus came from the 3rd District on gathering those signatures, but also in my part of the state, a tremendous amount of support, and yet you failed in that. So I have a difficult time taking all this highfalutin language about fiduciary duties, about membership rights, democratically elected people, and all that. It rings pretty hollow.
And Senator Patton, thank you, because I fully agree with your statements, and if you followed it very closely, you'll know I'm on record and taking a vote to oppose that decision. And I'll know that the members heard that, just like you've heard that, the members were upset. And the beautiful thing about this organization is that it's democratically elected. In every election for the last 2 years, except where an incumbent has citizens, there's been contested elections, heavily contested elections where people are debating ideas and bringing them forward. And the point is, when I was a first-year governor in a 3-year term, I voted against that. The members have been heard, they've been electing people to bring that reform to the point where they've elected someone who's outspoken like me, who is against that decision and pro-reform, making sure that the members are heard and we're focused on being a service-oriented agency to make that change happen. But just like with this body, and I'm sure you don't always agree on this committee, change takes time to happen. Democratic change takes time to happen. It is happening. The board is moving in a direction I think you would be very favorable of. And the point of the matter is that the members have spoken up with the same concerns you had with outrage, and they've been making that change through their statutory rights to make that change. And that's what's beautiful about the system. It doesn't turn on a dime. Democracy is messy, and this democracy is sometimes slow. It's not authoritarian. But that's the beautiful thing about it, is it can change through the will of the people.
All right, we're going to need to move on, but thank you all very much for coming forward. Let's bring up next Rick Bartholomew, Gene Cotton, and John Scannell. Please proceed.
Good morning, Chairman Peterson and members of the committee. My name is Rick Bartholomew. I'm here on behalf of the Domestic Relations Attorneys of Washington. I realize this is not a direct domestic relations bill, but we have almost 600 members, all of whom are licensed attorneys in Washington, and they have a big stake in what's going on. And DRAW, as we're known, is opposed to this bill. I want to speak a little bit to the question that Senator Padden was asking. The Board of Governors, or the governors who just testified, I think were helpful in explaining much of the history of what's been going on. But yes, a lot of attorneys were dissatisfied with the direction of the bar, and that's why there have been what have been termed reform governors that have been elected, and finally the reform governors are in a majority. There has been a change of direction. We have the executive directors will no longer be with the bar as of March 31st. And the Board of Governors is now, through the work group, trying to resolve, and I think there's a good chance it will resolve, the problems that the members have brought up. So I agree with some of the testimony that this bill is premature. We need to let the bar try to internally resolve those problems. DRAW member Eric Nelson stated, please oppose HB 1788 abolishing the state bar. Regardless of whether eliminating the bar would be a good or bad idea, no long-established and active entity can be simply abolished without creating a financial and legal catastrophe. The bar has employees and ongoing employee benefit obligations. It has leases and other ongoing financial commitments. It has assets to preserve, debts it owes. It is always organizing and conducting CLEs. This goes on, and I notice I'm already out of time. But the point is, this is a very large institution. I think it's going to take some time. Maybe eventually a bill such as this will happen, but we need to some time to figure out what we're going to do and what this is going to look like in the future.
Thank you. Please proceed.
My name is John Scannell, and I'm an attorney in the Ninth Circuit that represents several people and organizations that are currently suing the bar. And with respect to this legislation that's before you, I'm speaking against the striking amendment, and at least somewhat supportive of the vote that was taken by the House at 96-1. It seems to me that this striking amendment has missed the point as far as what the original intent of this legislation was. It was, like I said before, it was in response to Janus, and it was in response to the North Carolina dental examiner's case. With this legislation, the striking amendment, the WSBA will still be a mandatory bar. It will still be politically controlled by the same special interest groups. It will even have a stronger claim to Sherman antitrust exemption as a state agency, and they'll try to claim it, but they won't get away with it. It will still have lawyers policing the disciplinary process, the same fox and the chicken coop mentality that the American Bar Association has condemned for over 40 years, and 19 states have rejected. Now, what is particularly disturbing to me about this process is it's being proposed by apparently the chairman, who is again a Washington State Bar Associate. This striking amendment has hidden consequences that I don't think that you're even aware of. They're talking about handing over for example, the right for the Washington State Supreme Court to change the name of the Bar Association. What has that got to do with Janus? And what has it got to do with the antitrust? I'll tell you what it has to do. Because under the present language, the Washington State Bar Association, each of the members are individually and collectively responsible for any lawsuits that are filed against the association. There's been a movement within the bar and within the Supreme Court to try to say that it's no longer an association. And what that does is it has the consequences for the taxpayers. Now you've heard a lot from the attorneys here today, but for you non-attorneys that are on this board, you have a fiduciary responsibility to act on behalf of the taxpayers and not this group of attorneys that are over here that are trying to escape responsibility. As far as we're concerned, if this striking amendment goes into effect, which increases the possibility of taxpayer liability and decreases the possibility of individual attorney responsibility, we are going to demand under Article 2, Section 30 of the state constitution, which forbids bribery and corrupt solicitation, that a member who has a private interest in any bill or measure proposed or pending before the legislature shall disclose the fact to the House in which he is a member and may not vote thereon. What we're saying that means is because this striking amendment reduces the possibility of individual attorneys being held accountable for the antitrust activities of the Bar Association in the whole, and foisting it onto the taxpayers, that they have not only a responsibility to disclose it, they have to disqualify themselves from voting, and certainly shouldn't have any role in proposing it, which is exactly what's going on right now. We're saying...
Could I ask you to wrap up, sir?
Yes. And so our position is very clear. We actually like the original bill that was before the House. It addressed Janus. It abolished this group over here, which has been misusing their powers. And the bill that passed the House we'll live with, but this striking amendment, we're going to fight in court.
Thank you. Please proceed.
Good morning, Senator Peterson and committee members. My name is Jean Cotton. I am here today in my capacity as the president of the Grace Harbor County Bar Association, just up the road, and roughly 100 members. But I'm also here as a citizen of the state of Washington and a licensed attorney in this state for the last 25 years, quite frankly, very proudly to be one. I've been involved with state bar business and served as a liaison to our Board of Governors for various entities since 2006 and have rarely missed a meeting in all those years. I dare say there are not many people in the state of Washington that can say that. It's not an employee of the bar. But I'm here today to ask you to please stand down, to please oppose any form, any iteration of this or any other bill to repeal the State Bar Act or change the status quo at this time. What my fellow governors and attorneys and my president-elect said to you is true. Senator Patton, what you said is true. I was there at the meeting in Spokane when literally all hell broke loose. And I was one of the people screaming and shouting, we've got to fix the problem. There were problems, there's no question about it, and it was frustrating. But as the governors and the president-elect informed you, the members rose up. We have used our vote to change the body. The reform governors, as they're now being referred to, are beginning those steps in the right direction to fix the problems, and they've taken huge leaps forward, but there's a long way to go. And the structures work group will be a part of that process. We don't know what the outcome will be. So not only do I urge you to oppose the bill, I urge you to send a representative, preferably one of you, to the open meetings of the structures work group and to work with the BOG to fix our bar to protect the citizens of this state and the 40,000 lawyers who attempt to serve them. Thank you.
Thank you very much. Do we have any questions for this panel? All right, thank you so much for coming forward. We'll bring up our last folks, Arthur West and Hugh Spitzer.
Good morning, Chairman and members of the committee. My name is Arthur West. I signed in other on this bill, but I do support it. It's just that I support the original version of the bill that passed nearly unanimously to the House more. I also testified on that bill, and in it I said that the Bar Association as it currently exists is broken. The bar is full of dissension. The disciplinary process has never worked well and has been broken down as a classic case of the foxes in charge of the hen house. Citizens have a general perception that it's impossible to get bar members disciplined, especially the politically connected ones. I'll point out two cases that illustrate this. Spice versus Pierce County. An attorney sued Pierce County and the city of Puyallup on behalf of a woman who had been dead for 4 years. And State versus Walker, where the Supreme Court found egregious prosecutorial misconduct. If the Bar Association worked, attorneys wouldn't be doing this. I myself was physically assaulted by an attorney in the Pollution Control Board. Still, when the weather changes, my arm gives me a problem. Bar Association did nothing. Those are examples of a broken organization. So I urge you to take this necessary action to fix this. And I'm concerned, though, about this structures work group. I was the only citizen who testified about this bill. I haven't even been contacted. I would ask that this body establish a work group, move forward to necessarily change this organization to be in line with federal precedent, and establish a actual public work group with the legislative participation to determine what the results of this reform are, so that we don't have some secret star chamber organization making these reforms. I don't want a corporate attorney determining the future of our Bar Association in some backroom deal. Thank you for your time.
Thank you, Professor Spitzer.
Thank you, Mr. Chair, members of the committee. My name is Hugh Spitzer. I'm a professor at the University of Washington Law School, but I'm here speaking on behalf of myself, not on behalf of the University of Washington. I was also a working lawyer for more than 40 years. I had the privilege of serving on the governance task force of the Washington Bar Association in 2013 and 2014. And one of the key things that task force put in its report and discovered was that in the State Bar Act, there are at least 16 sections that have been essentially overruled, superseded by actions of our state Supreme Court through rule or other action and by federal court decisions. The State Bar Act is basically a fossil and almost entirely empty shell, and the leftover pieces are siege, really, by Janus, both by antitrust and by First Amendment cases. I support the legislation, but I think it's very important to enact the striker before acting on the legislation. The striker makes it clear that the Bar Association can continue under the court. It basically reflects what is the fact that the Bar Association is fully under the court, but that it can continue as a separate entity and a corporate entity with corporate powers and will not vanish. Also, it importantly pushes off the effective date until July 1st of next year. I think that's very important. I think this legislation will support the court and support the work group and will help move the ball forward. Thank you.
Thank you very much. Do you have any questions for this panel? All right, seeing none, I think you're off the hook. Thank you very much for coming forward. That'll conclude our public hearing on Ingress Substitute House Bill 1788, and that concludes our work for the day. We're adjourned.
Did you get Arthur's?
Oh, yeah.